says 7.
$700. All right, and that's what that adds up to. So 7,003, 395, 1465. I need to make a note on here for Patty that you're going to need an interpreter.
Okay. And his language is Bourbon, right?
I think so.
Okay.
All right, I'm going to send all this back with you, and then when you bring it back, bring it all back. And then you can just give him a copy of this,
Okay.
and then I'll get him a copy of that. You don't have to give him a copy of this stuff.
Okay.
Thank you for helping today.
No problem.
I'm going to have him sign this one. All right, Richard, Mr. Thing. Mr. Thing. All right, Mr. Chinchum, if you'll interpret this for Mr. Thing. The court has approved Mr. Thing for the appointment of an attorney. And his name is Mr. Richard Schmidt. And I'm going to give you a copy of an order that has his phone number and address down there for you to contact him. The court has issued conditions of pretrial release associated with your bail or bond. And there are certain requirements that you're going to have to comply with in order to stay out of jail while you're pending this case. So I'm going to send you to speak with the probation department. You need to go over all of these and sign this page. All right, and this is a copy for Mr. Thing. Rachel. Mr. Thing, I need you to go with Officer Matura here, and she will go over the conditions of pretrial release. just go run that. All right, and so before you go, we have a notice of appearance form. I'm going to reset his case to September 30th. Yes, 30 at 2 o'clock. Same time. Yes, sir. I'm going to have Mr. Thang sign this notice of appearance form that's just going to tell him when to come back. Let me write on that too. All right, he'll sign down here at the X. And then go see Officer Matura. Wait till you sit down and then I'll call you and ask for something else. You know that's how it's gonna work. I don't think so, Wayne. Thank you. You know, I'm gonna change a note on my docket for that Chester Taylor. I see here that there was a release of surety granted on June 17th. So there is a warrant for Mr. Taylor already out on both of these cases. No. And we'll go over them again because we're going to call all of them. I guess I should have called this morning, but it's okay. We'll knock them all out this afternoon. Nah, we'll wait. We'll just knock them all out. And at 2:30, there's going to be Whitaker, Clint Whitaker. He already has a release of surety. It's probably not going to show. I'm going to call it anyway. All right, that'll be all of that on that note. Miss Herndon, we pled her, right? She was that next to last one. That's what I thought. Okay. I'll go back to my morning docket here. And Jacob Daniels, what do we do with him? We plead him? Yeah. He was the nurse type guy, right? Had the scrubs on.
Jacobs.
Yeah, Daniel Stoney Jacobs. Yeah, we pled him.
Yes.
Okay. So I just forgot to mark it. So, Christina Mann, that she was reset for plea 9:30. What about Rico Armando? We pled him too. We pled him too. He was a Hispanic guy, black shirt, beard. We pled him to marijuana. Kagan Smith is still here. Thank you, sir. All right, Mr. Schellenberger, you ready? This is cause number 2020-248. And Mr. Schellenberger, I placed you under oath previously today. You recall that? You're still under oath for this purposes of this plea, okay? All right. You are Alan Wayne Schellenberger Jr. Is that right? Mr. Schellenberger, previously you appeared before the court and requested a court-appointed attorney. The court admonished you regarding your right to counsel, to hire counsel, to have one appointed. The court reviewed your financial application, found that you were not indigent at this time. And at that time, you indicated to the court that you wish to waive your right to counsel and to speak with the state, and you've done that. Is that right? And it appears that in your speaking with the state, you have decided to enter into a plea agreement with the state and continue with your own self-representation. Is that right? Understanding that you have the right to counsel and that you also have the right to waive that counsel, you're indicating to the court that you want to represent yourself and enter into a plea agreement with the state today. Is that right? You're charged with a Class B misdemeanor offense of driving while intoxicated that carries a range of punishment of up to 180 days in the county jail and a fine not to exceed $2,000. Any plea agreement that you have with state or any sentence imposed by the court must not exceed that range of punishment. I see here that there's a plea agreement that you would plead guilty to that offense and that in exchange, the state's recommending that your punishment be assessed at the maximum 180 days in jail, but they're recommending that that sentence be suspended and you be placed on probation, community supervision, for a period of 18 months and that you receive a $1,500 fine. Is that your agreement with the state? You know that you will also have court costs of $270. You'd have a $15 reimbursement fee, and there's also a $100 EMS or trauma fine. You understand that? You agree to those things? All right. Mr. Schellenberger, are you a United States citizen? Do you read, write, speak English? Ever been diagnosed with any type of mental condition? All right. Then I'm going to ask you at this time, how do you plead to the Class B misdemeanor offense of driving while intoxicated? And are you pleading guilty because, in fact, you are guilty of committing that offense? Okay, I see some hesitancy on your part. Now, I know that sometimes it can be difficult to admit guilt for something. I also know that it's difficult sometimes to face consequences and to take that on. But what I've got to be assured of is that you are intentionally, knowingly, and voluntarily entering your plea of guilt. And that's what you want to do. So is there any hesitancy that I'm picking up on your part where you feel like you're not guilty? For sure.
I just didn't know what intoxicated.
Okay. Intoxicated, slang word is drunk. Intoxicated, the legal definition of intoxicated is not having the normal use of your mental or physical faculties due to the introduction of alcohol or a controlled substance or a combination of the two into the body, or by having a blood alcohol concentration of 0.08 or greater. That's intoxication. Okay, so I'm going to ask you again. So how do you plead to the DWI Class B misdemeanor offense? And you're pleading guilty because you are guilty of being intoxicated. and driving. Okay. And court will accept Mr. Schellenberger's plea of guilt. The court will find that Mr. Schellenberger has not been forced or pressured to plead guilty today. Is that correct? All right, court makes that finding and also takes judicial notice of Mr. Schellenberger's judicial confession. Court admits State's Exhibit 1, the stipulation of evidence. Anything further from the state?
Nothing further, no.
Anything further?
Yes, further.
You have, okay, good. Let me have those, Mr. Schellenberger. Thank you. Mr. Schellenberger, is there anything else that you have to say about this or any questions about it? And throughout these documents, anywhere that your signature appears, you're telling the court that that is your true and correct signature, and you sign there only after reviewing the documents and indicating that you understand what's in those documents, correct? Okay. All right, Mr. Schellenberger, based on the evidence before the court will find that there is sufficient evidence to convict you of this offense of driving while intoxicated. The court will follow the plea agreement that you've reached with the state. Court hereby convicts you of the Class B misdemeanor offense of driving while intoxicated. Court assesses your punishment at 180 days confinement in the Van Zandt County Jail. Court will suspend that sentence and place you on community supervision for a period of 18 months. Court assesses a $1,500 general fine, a $100 EMS trauma fine. Court assesses court costs of $270 and reimbursement fees of $15. Mr. Schellenberger, have you been on probation before? You've taken the time to review your conditions of community supervision, haven't you? So you know what's required of you. And you understand that a single violation of any one of those could result in you being brought back before the court. And if the court finds that you violated, the issue at that time will not be whether or not you were driving while intoxicated. The issue will be whether or not you violated your community supervision. You understand that this plea means that you are waiving your right to a jury trial on the issue of driving while intoxicated. Okay. So that means that the court expects strict compliance with your conditions of community supervision. And I don't want you to come back in here and say, well, I didn't know what the ramifications were if I violated. All right. So I'm telling you right now, if you violate, the court could, if the court finds that to be true, the court could revoke your community supervision and could put you in jail for up to 6 months. Now, I recall what you told me earlier is that CPS in another county is looking at making you the custodial parent of your child or children, right? So now you've got this county having conditions, this court having conditions upon your shoulders. And so if you violate that community supervision, you're going to put yourself in a position where your kids may be removed and put into the government's care. And that's never good for a child unless the child has nowhere else to go or they're not being, provided a safe home. All right. So usually I would say that having a jail sentence over your head would be sufficient enough. But, as a father, I think that having a jail sentence is not nearly hanging over my head is not nearly the pressure and the importance of being there for your kids and not forcing them into a governmental placement somewhere. All right. So I want you to think about that. If you ever think about violating, not only will you be looking at up to 6 months in jail, but I can guarantee you CPS is going to take your kids if you're the custodial parent. Understand? All right. I know that you do. but it's incumbent upon me to make sure. Okay. All right, Mr. Schellenberger, you're hereby remanded to the custody of the Van Zandt County Community and Supervision Corrections Department so they can carry out the terms and conditions of your sentence. I'm gonna have you go with my bailiff here to be fingerprinted. After that, you need to report to the probation department and they'll give you further directions, okay? All right, time to go to work. All right, let's call the 2:30s. Yes, ma'am.
It's really freaking out because it's saying 3 days confinement, but I'm explaining to him that it's time served. So I just wanted to, because I don't want to give him any legal advice, but I'm like, no, he thinks he's going to jail today. I said, you're like, he wants to do the time served. So when you say that, he may.
Okay,
Just a,
so you're telling me I shouldn't pause very long
Yes.
between.
but when you
sentence.
say you're remanded to the sheriff's office, he may flip out. But
Okay,
I explained to him that it's part of the document. but
okay,
Just a precursor.
thank you, I appreciate that heads up. All right, let's call these 2:30s real quick. Obviously, we don't have where they're at. We had someone that was supposed to appear via Zoom. She has not. All right, you ready? Court calls 2020-276, State versus Grametia Thomas. I do not see Ms. Thomas logged in on Zoom, nor has she appeared in the courtroom. FC 20-52, Amber Valdez. Ms. Valdez is not present in the courtroom. 2020-258, Gerardo Velasquez Hernandez. Not present in the courtroom. Twenty 20-261, State versus Clint Jacob Whitaker. Record will reflect that a release of surety was granted on July 2nd, 2020, and there is a outstanding warrant for Mr. Whitaker. Mr. Nicholas, do you know anything about Ms. Thomas? I had a note that she was going to appear via Zoom today.
She's not logged in.
No, you want to see if you can get her?
Yeah, she preferred.
Mr. Smith? All right, this is cause number 2020-247, State of Texas versus Kagan Michael Smith. And Mr. Smith, you'll recall earlier, I had you sworn and put under oath. Do you recall that? So you're still under oath for all purposes. All right. Mr. Smith, are you a United States citizen? Do you read, write, and speak English? And have you ever been diagnosed with any type of mental condition? Earlier today, I gave you some instructions and reminders regarding your constitutional right to have an attorney represent you in this matter. And I believe that you, after being admonished by the court, you decided that you wanted to represent yourself and you wanted to speak with the state regarding a possible plea agreement. Is that correct?
Yes, sir.
And it appears to me, based on the documents in my hand, that you've reached a plea agreement with the state. And throughout these documents, I see your name on several documents entitled written plea admonishments, the stipulation of evidence. Does that indicate to me that you have taken the time to read these documents and that you're certifying that you understand them with your signature?
Yes, sir.
Is that your true and correct signature there on these documents? And you're asking the court to allow you to enter into a plea agreement today. Mr. Smith, you have been charged with a Class B misdemeanor offense of driving while intoxicated. A Class B misdemeanor has a range of punishment of confinement in the county jail for a period not to exceed 180 days, nor a fine to exceed $2,000. Any plea agreement that you reach with the state or any sentence handed down by the court cannot exceed that range of punishment. You understand that? And it appears to me that the plea agreement that you've reached with the state is that you're going to plead guilty to the offense of driving while intoxicated. The state, in exchange for that agreement, is going to recommend that your punishment be assessed at 3 days in the Van Zandt County Jail. And they're requesting the court to give you credit for the 3 days of time that you've already served in jail, and a $1,500 fine, plus a $100 EMS trauma fine, court costs of $270, and reimbursement fees of $15. Is that the agreement you've reached with the state?
Yes, sir.
At this time, Mr. Smith, I'm going to ask you, how do you plead to the Class B misdemeanor offense of driving while intoxicated? And Mr. Smith, are you pleading guilty because you are guilty of committing that offense? Has anyone threatened you, forced you, or otherwise pressured you to plead guilty to this offense?
No, sir.
All right, the court will accept Mr. Smith's plea of guilt. Court's going to admit State's Exhibit 1, the stipulation of evidence, and the court takes judicial notice of Mr. Smith's judicial confession. Anything further from the state? Anything from you, Mr. Smith? And you feel like you understand everything that you've read, signed, and that's occurred in this proceeding? All right, then based on the evidence before the court's going to find that there is sufficient evidence to convict you of this offense. The court will follow the plea agreement, Mr. Smith. Court will convict you of the Class B misdemeanor offense of driving while intoxicated, assesses your punishment at 3 days confinement in the Van Zandt County Jail. Court awards you 3 days credit for time served. Court assesses a $1,500 general fine, $100 EMS trauma fine, $270 court costs, and $15 reimbursement fee. All right, Mr. Smith, in order to carry out the judgment of the court hereby remains you to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of your sentence. What that means is I'm going to have you step to your left here to be fingerprinted Once you're fingerprinted, then you're going to get a copy of this judgment and you'll be free to go. And you'll need to either step across the hall and pay your fines and court costs and fees. And if you cannot discharge all of those today, then you can go down at the end of the hall to the left and speak with the court compliance officer to make payment arrangements to discharge the rest. Okay? We'll go with the bailiff here to be fingerprinted. I didn't even see you there. I thought there was another bondsman in here. What's Jimmy Pickens doing here? Yeah, let me do this real quick. think Ms. Thomas is having some technical difficulties.
Connecting to audio.
I know, but she's not, she hasn't moved in a couple minutes, so I think her screen's frozen. Mr. Nicholas is not behind the podium, is he?
He just.
Okay. I was wondering if he was trying to get hold of Ms. Thomas. Because she's having some technical difficulties.
Would you like me to ask him to start again?
Yeah, just let him know his client's not connecting. Oh, okay. It's like a comedy. Aaron just went out to get you. No, it's okay. Stay right there. Stay right there. Because if you go, she comes back in. And then I start wondering if you are the same person. Ms. Thomas is having some technical difficulties. Her screen's frozen. Can't see her. Oh, there she is. Let's see if she's moving.
Still says connecting to audio on the site. And she's very.
Ms. Barker's on the phone with me right now.
Okay. Is that who she's speaking to?
Yes, sir.
Just going to put her back in the waiting room. Would you message Waynette and have her message you whenever she's got her issues figured out? Mr. Thomas? All right, you ready, Joe? This is cause number 2020-310, State versus George Luis Thomas. Mr. Thomas, you will recall earlier today, I placed you under oath to tell the truth. You understand that you're still obligated to tell the truth? Okay. And you are George Luis Thomas, is that correct? And Mr. Thomas, you and I had a discussion earlier wherein I admonished you and informed you that you have the right to have an attorney represent you. And you also have the right to have an attorney appointed to you if you can't afford one. And at that time, you indicated to me that you wanted to waive your right to an attorney and you wanted to speak with the state to see if you could work out your case. And it appears to me that you have reached a plea agreement with the state. Is that right? And you're still wanting to proceed without an attorney in this case. Okay. Mr. Thomas, are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
And have you ever been convicted? I'm sorry, have you ever been diagnosed with any type of mental condition? And in this case, you are charged with a Class B misdemeanor offense of boating while intoxicated. A Class B misdemeanor carries a range of punishment not to exceed 180 days in the county jail and a fine not to exceed $2,000. So any agreement or sentence handed down by the court cannot exceed 180 days or a $2,000 fine. Do you understand that? The plea agreement appears to be that you're going to plead guilty to that offense, and the state's recommending that your sentence is set at 180 days, which would be the maximum, but that sentence would be suspended and you would be placed on community supervision for a period of 18 months, and that you would receive a $1,000 fine, general fine, a $100 EMS or trauma fine, and $270 court cost, and a $15 reimbursement fee. Is that your agreement with the state?
Yes.
All right, Mr. Thomas, then to the Class B misdemeanor charge of voting while intoxicated. How do you plead? And Mr. Thomas, are you pleading guilty because in fact you are guilty of that offense and for no other reason?
Right.
And has anyone threatened you, forced you, or pressured you to plead guilty before the court?
No.
All right, court will accept Mr. Thomas's plea of guilt. And the court will also admit State's Exhibit 1, the stipulation of evidence, and will take judicial notice of Mr. Thomas's judicial confession. Is there anything further from the state?
Nothing this time.
Mr. Thomas, anything you want to discuss or be heard on?
No, sir.
And Mr. Thomas, your signature appears throughout the documents before the court. Have you taken the time to read those documents, and where you have signed, does that indicate to me that that is your true and correct signature and you've only signed because you understand the documents and you want to do the plea agreement? Is that right? All right, Mr. Thomas, based on the evidence before the court, the court's going to find that there's evidence to convict you of this offense. The court hereby follows the plea agreement. Court convicts you of the Class B misdemeanor offense of voting while intoxicated, assesses your punishment in accordance with the plea agreement at 180 days in the Van Zandt County Jail. Court will find it's in the best interest of the community and the defendant for that sentence to be suspended and for you to be placed on community supervision for a period of 18 months. Court assesses a $1,000 general fine, $100 EMS trauma fine, $270 court costs, and $15 reimbursement fee. Mr. Thomas, that's a very expensive day on the lake, is it not? Not going to make that mistake again? Haven't yet. Are you going to? You don't know? Well, if you're going to, one, I would tell you that I wouldn't do it while you're on conditions of community supervision. Okay? You understand that you violate any one of these, and the condition number 1 says you shall not commit any other violations against the laws of this state or another state or the United States. It means you get a voting while intoxicated here or Kaufman County or Dallas or Tennessee. Doesn't matter. That's going to be a violation of this agreement that you have with the state. If you violate and the state files a motion and they prove it to the court, then the court can revoke your community supervision and lock you up for 180 days. They don't let you go get out on the lake when you're locked up for 180 days. You understand that? Okay. All right, you're hereby remanded to the custody of the Van Zandt County Sheriff, to the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. I'm gonna have you step to the left here with my bailiff to be fingerprinted. After that, report to Officer Mature here with the probation department.
Say that Ms. Parker did it and Ms. Thomas is trying.
We need
All right, Ms. Thomas is having same technical difficulties. I'm going to put her back in the waiting room. You ready? I'm going to call it 3 o'clock. Christopher Applewhite, I'm going to call your name. Just say president here. Christopher Applewhite. Catherine Hutcherson. Dakota Malawick. Sandra Zarate. Sandra Zarate, not present in the courtroom. James O'Brien. James O'Brien, not present in the courtroom. All right, Mr. Applewhite, Ms. Hutcherson, Mr. Malawick, if all 3 of you will approach, please. We're going to come up here and kind of spread out here where the bailiff is. Do me a favor. Let's line up Applewhite, Hutcherson, Malawick. There we go. All right. Keeps me in order. Mr. Applewhite, you're here for a plea today. Is that correct?
Yes.
You've already,
I'm speaking with someone and they tell me about the findings.
okay, go ahead and have a seat. Okay, thank you. And Ms. Hutcherson's here for a plea also. You can have a seat, Ms. Hutcherson. Hutcherson. And that just leaves Mr. Malawick. Mr. Malawick, I show that you've already been to court before, right? And I show that, are you representing yourself in your case? I show that we're set for pre-trial today. You got a plea agreement?
Judge, we'll check on all 3 of those.
Okay, just go ahead and have a seat, Mr. Malawick. Thank you, sir.
Ms. Anderson, Angela Thomas.
Mhm.
I show that Ms. Dunn was appointed yesterday, so I don't think she probably got notice.
Yeah, the attorney probably didn't. And I'm gonna go back to make sure that Ms. Thomas got notice.
Okay.
Okay, that's
I-
like
I
Mr.
was
Manning, so
checking-
Jonathan, he didn't know either,
I
and
was-
neither did Jeff Wood.
Okay, yeah, I was checking with the clerk's office for a waiver and I saw that she was appointed yesterday. So
Okay.
Hello?
Okay, Ms. Thomas, you can see and hear us now?
Yes, I'm in there.
Okay, good, good. Okay, we can hear you. That's an improvement. I was wondering if we were gonna get that to work. Okay, this is in cause number 2020-276, State of Texas versus Gramecia Shanae Thomas. Ms. Thomas, you are set for arraignment today in the county court at law. And you're charged with possession of marijuana less than 2 ounces, a Class B misdemeanor. And are you going to hire an attorney to represent you in this, or are you going to represent yourself, or are you going to be requesting a court-appointed attorney?
I wanted to hire my own lawyer, but I also wanted to see what are the options for court-appointed lawyers. I don't know. I have a lawyer here in Shreveport where I'm from, but I didn't retain him because he couldn't make it today. He's like a family lawyer that does stuff here. So traveling, he said, would be a little hard for him. So I was just gonna, I guess I have to get one around the area.
Well, my recommendation would be to hire someone who is licensed in the state of Texas.
Okay,
Someone who is licensed in the state of Louisiana may not be able to appear and practice in this court. So if you're going to hire an attorney, I would recommend that you hire a Texas attorney. And obviously, if you get one in this area, they are going to know the procedures of court better than anyone else. But you can hire any attorney who is licensed to practice in the state. Is that what you want to
okay, that is what I want to do.
Okay, then what I'm going to do, Ms. Thomas, is I'm going to reset you for September 30th
Okay,
at 2:30, the same time.
okay,
And I'm going to set you for arraignment, and you're to appear with your attorney, or if you hire your attorney before then they can file a waiver of arraignment and get you a different setting, okay?
okay. Different setting, what does that mean exactly?
Well, I'm going to set you for September 30th for arraignment, okay, the same setting as today. And if you hire an attorney, that attorney could file a waiver of arraignment for you for that date and get you a different date.
Okay, I
You
understand.
may not have to appear on that date, okay?
Okay,
All right, so this is going to be the only notice that you get. You're not going to have a notice mailed to you by this court or anyone else. So you need to write down September 30th at 2:30 p.m.
okay, I got it.
All right, and then the court's going to expect you to have an attorney hired by that time.
Okay,
All
thank
right.
you.
All right, thank you. Have a good day.
Same to you.
I think that's the correct one. I think in the past, other reason? All right, the court's going to accept Mr. Malowick's plea of guilt. Court's going to admit State's Exhibit 1, the stipulation of evidence in this case, and the court will take judicial notice of Mr. Malowick's judicial confession. Mr. Malowick, based upon the evidence before the court and your judicial confession, court will follow the plea agreement in this case, hereby assesses your punishment at a $500 fine, $180 restitution, $76 court costs, $15 reimbursement fee, convict you for the Class C misdemeanor offense of theft of property greater than or equal to $100 but less than $750. Mr. Malowick, are you paying your fines and court costs today? Can you pay anything today? How much can you pay today? All right, Mr. Malowick, and the court is going to order you to go across the hall and pay your $300 towards your fines and fees and court costs. And then any amount that you are not able to pay today, you're to report to Miss Bonnie LaPrade. You know, step up, I'm gonna give you this card right here. Miss Bonnie LaPrade, she's located, her office is at the end of the hall on the left. Go in there and speak with her about setting up a payment plan for the amount that you do not pay off today. All right. All right, I'm gonna have you step over here to your left to be fingerprinted with the bailiff. Once you get a copy of this judgment, step across the hall, make your payment, and then go see Miss LaPrade for the payment plan. She's a little America's sweetheart, you know. Hmm? Yeah. That's right. Oh, I'm texting you right now.
I wasn't going to answer.
So Applewhite, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. All right, you are Christopher Applewhite, is that correct? Mr. Applewhite, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? You've previously appeared in this case and waived your right to counsel. And I believe that you have been admonished by the court that you have the absolute right to have an attorney to represent you in this criminal matter. Do you understand that? And I believe previously you waived that right to an attorney and you chose to represent yourself. Is that right? And you're still wanting to do so today. And you're wanting to enter into a plea agreement with the state of Texas to resolve your possession of marijuana charge. And the plea agreement appears to be that you would plead guilty to a Class B misdemeanor, possession of marijuana less than 2 ounces, in exchange for 4 days in jail with credit for 4 days of time served, a $1,000 fine, $270 court costs, $15 reimbursement fees. Is that your understanding of the plea agreement?
Yes.
The range of punishment, Mr. Applewhite, for a Class B misdemeanor offense is jail time not to exceed 180 days or a fine not to exceed $2,000. So looks like your plea agreement would fall well within that range and would be illegal. Okay. So at this time, let me ask you, how do you plead to the Class B misdemeanor offense of possession of marijuana less than 2 ounces? How do you plead? Guilty, not, there's your options: guilty, not guilty, or no contest, which will have the same legal effect as guilty. Okay. And Mr. Applewhite, are you telling me that you're pleading guilty because you're guilty of committing this offense and for no other reason, right? And Mr. Applewhite, has anyone threatened you, forced you, or pressured you to plead guilty to this charge? Court will accept Mr. Applewhite's plea of guilt. Court will admit State's Exhibit 1, the stipulation of evidence, and takes judicial notice of Mr. Applewhite's judicial confession. Mr. Applewhite, throughout these documents, I see your name. Where the court finds your name, does that indicate to me that this is in fact your true and correct signature?
Yes, sir.
And you've signed here indicating that you've read these documents, that you understand them, and you certified it with your signature. Is that right? Okay, these are just my copies. Okay. All right, Mr. Applewhite, based on your judicial confession and the evidence before the court will follow the plea agreement in this case. The court hereby convicts you of the Class B misdemeanor offense of possession of marijuana less than 2 ounces. Court assesses your punishment at 4 days confinement in the Van Zandt County Jail with credit for 4 days time served. Court assesses a $1,000 fine, $270 court costs, and $15 reimbursement fee. Mr. Applewhite, how much can you pay towards your fines and court costs today? Well, I mean, I'm ordering you to pay that, so you do have to pay it. I'm saying, how much can you pay today? All right, then you need to go across the hall to the clerk's office, pay $100 or as much as you can towards your fines and court costs. And then you're ordered to go down to the end of the hall and meet with Miss Bonnie LaPrade, the court compliance officer. to set up a payment plan to discharge the rest. Your failure to pay your fines and court costs is going to result in a warrant being issued for your arrest. Okay. All right, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. I'm going to have you step to your left, be fingerprinted by the bailiff. Once you get a copy of this judgment, go across the hall, make your payment, and go down and see Ms. LaPrade.
About, that wasn't.
Wasn't? Okay, good. Thank you. Okay, good. Perfect. Okay. I'll let you keep that for Patty's file. And this will go to her.
Do I need to bring you two pre-trial conditions or just the one?
I know, I get Rachel to sign these for
Okay.
me. I'm trying to remember. This will go to Rachel to get filed. Okay. Just keep that for Patty. Mr. Rate? Mr. Rate, this is cause number 2020-265. You have applied for a court-appointed attorney. The court has reviewed your application of affidavit of indigency and application. Court hereby approves your indigence and appoints the Honorable Ann Thompson to represent you in this matter. I'm going to hand you an order relating to the appointment of Ms. Thompson. It's going to contain her phone numbers and her address. You need to make contact with her. It may be a few days before she's aware of this appointment. So I would say by Monday of next week, she would be aware. So you need to contact her immediately next week. I'm going to set your case for arraignment on September 30th at 3 p.m. Yeah, I'll write it right here.
It's gonna place on there to write it in. Patty, I'm gonna be sure I wrote those in.
Write it in. Oh, there. Okay. We're going to give her notices. I was just for Ann probably.
Mhm.
Okay, I haven't been writing those in. I didn't know about that.
I did earlier.
Okay. And the court is going to condition your bail with pretrial release conditions, Ms. Zarate. So what I'm going to do is I'm going to give you a copy of this that has your attorney information on it. Let me write this on here too. And then I'm going to have you sign this notice of appearance. Mr. Kane, will you see if Officer Matura is available to go over these conditions with her?
Sure.
All right, Ms. Kane, I'm going to have you go with Officer Matura here. She's going to provide you with a copy. You're going to sign these conditions of pretrial release, and she's going to provide you a copy. And then you get in contact with Ms. Thompson, and we'll see you back on September 30th, okay? Yeah,
Order
sure.
to Patty.
Rachel, you usually take that order, don't you?
Yes.
Yeah, she usually takes it and files it.
I didn't make myself a copy.
Let's see here. Have I missed my 3:30 people? All right, let me call those real quick so we can get them in the mix. At 3:30?
I think we're getting into the people we've spoken to previously, Judge.
Tell me who has pleas.
Thompson.
Thompson's a plea, okay.
Gilliam, Hutcherson.
What about Taverner? Taverner, he's at 3:30. I'm going to call the 3:30 cases. When I call your name, please say present or here so I can mark you down on the docket. Marcus Gardner. Is Marcus Gardner here? Aaron Taverner. Jason Thompson. All right, Mr. Taverner, if you'll approach. Mr. Taverner, is this your first appearance on your case in court? Okay. And did you reach an agreement with the state at that time, or?
I'm still in the deliberating process as far as not as course of about counsel. And still, I'm not sure how to say right now, and I'm still investigating, finalizing direction.
So are you going to hire an attorney?
Yes, sir.
For sure.
No, sir. No, sir.
All right. So what we're going to do is I'm going to reset you. This will be your last reset. Okay. We're going to set you for September 30th. We'll do the same time, 3:30. And I expect you to have an attorney with you on that date. We're going to have this notice of appearance form. The bailiff's going to give that to you. Once you sign that, we'll give you copies and you'll be free to go. Free to go. See you back on that date. Did we figure out Mr. Gilliam?
Judge, he's gonna play right now.
Do you have a bunch of pleas down there?
Yeah.
Okay, is that it?
They're going over.
They're working on it.
a couple
Okay.
of them are going
Mr.
over.
Gilliam, come on up.
Working on it right now.
All right, Mr. Gilliam, raise your right hand. I'm going to place you under oath. Mr. Gilliam, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God? All right, you may put your hand down. All right, you are Preston Gilliam, is that correct? And Mr. Gilliam, are you a United States citizen? Do you read, write, and speak English? Ever been diagnosed with any type of mental condition? And you have previously waived your right to counsel in this case, and you're choosing to represent yourself, is that correct? And it appears that you have met with the state and you are wanting to enter into a plea agreement wherein you would plead guilty to a Class C misdemeanor offense of possession of drug paraphernalia. The state would be recommending your punishment be $500 fine and $76 court costs and $15 reimbursement fee. Is that your agreement with the state? All right, Mr. Gilliam, the range of punishment for a Class C misdemeanor is a fine not to exceed $500. Court finds that this plea agreement would fit within the range of punishment. So let me ask you at this time, Mr. Gilliam, how do you plead to the Class C misdemeanor offense of possession of drug paraphernalia? And are you pleading guilty because in fact you are guilty and for no other reason? Has anyone threatened you, forced you, or pressured you to plead guilty? Court accepts Mr. Gilliam's plea of guilt, admits State's Exhibit 1, the stipulation of evidence in this case. Court takes judicial notice of Mr. Gilliam's judicial confession. Anything further from the state?
Judge, this is a lesser included just for the court's information, but we have nothing further this time.
Okay. Mr. Gilliam, your signature appears throughout the plea paperwork. Would that, anywhere the court would see your signature, would that indicate to me that you've read the documents and you've signed certifying that that is your true and correct name and your true signature and that you understand the documents that you signed and read? Thank you, sir. Let's go ahead and have him sign that right there. That's where it says defendant. Is there a DLD trial?
They're
No
not
trial
in
courts?
Because it's not a jailable case.
So no certificate of appeal?
No.
All right, Mr. Gilliam, are you going to be able to pay your fine today? Can you pay anything today? All right. You understand that if you fail to pay your fines and court costs, that the court's going to issue a warrant for your arrest. All right. I'm fine with that, but what I want you to do is go down and see the court compliance officer, and I want you to get a payment plan just in case something happens between now and next week. Okay. And then whatever your payment plan is, if you come in next week and you pay it all off, then you don't have to worry about the payment plan. Okay. All right. I'm gonna have you step over here to be fingerprinted with my bailiff. Once you get a copy of that judgment, then go down there and set that up and you'll be free to go.
Mr. Gardner is here. They said they were sitting in the hallway. Didn't know they were supposed to come in here.
Okay, good. Mr. Gardner. How are you today, sir? How are you today? Good. Mr. Gardner, you're charged with a Class B misdemeanor offense of possession of marijuana less than 2 ounces. Purpose of today's hearing is for an arraignment for the court to make sure that you are the person who's been charged and that you're informed of what you've been charged with. And I want to begin by making sure that you understand that you have the right to counsel in this case. You have the right to hire an attorney to represent you. And if you are indigent and you can't afford an attorney to represent you, then you can apply to the court for a court-appointed attorney. So today you've got 3 options on how we're going to proceed. Okay. Option 1 is you'll tell me, Judge, I want to hire an attorney. Option 2 is, Judge, I don't make enough money and I think I'm indigent and I want the court to review my finances and then appoint me an attorney if I'm found to be indigent. Or option 3 is you can waive your right to an attorney at this time and you can speak with the DA's office, the state here, and find out what they're offering by way of a plea agreement. If you like what they're offering, then you can represent yourself, you can accept it. If you don't like what they're offering, then you can leave that conversation and you can come back to this court and you can say, I want to go back to option 1 and hire an attorney, or option 2 and request a court-appointed attorney. Okay. So it's not a permanent waiver of your right to counsel. You understand that? Okay. So I need to know what option do you pick? 1, 2, or 3? 1, you want to hire an attorney to represent you? Okay. All right. So if I reset this case until September 30th at 3:30, You believe that's going to give you enough time to hire an attorney and come back? And you're sure that's what you want to do? You don't want to talk with the state at all?
Judge, if I might, I believe Mr. Gardner has a couple other pending matters.
Okay.
Actually, so I was going to suggest that either he get court appointed or hire his own attorney.
Or do you have court appointed attorneys on your other cases? Okay, you've hired an attorney on your other cases?
Yes.
Okay. Mr. Nolan White? Okay, good. All right.
So we could talk to him about this if you want to, if that's fine.
All right, so what we're going to do, Mr. Gardner, my bailiff here has a notice of appearance form. If you'll just sign that saying you're going to come back on September 30th at 3:30. All right, you're free to go. We're getting close. We're getting close. Look, it's verified. Everything I say is verifiable. Look, we're down to a page and 2 entries. Page and 2, so that's 9 more that aren't in the courtroom. Actually, eight more that aren't in the courtroom. That's it. So we're getting close. Good by my standards. So, well, no, I need to do that, but no, we've got baseball for my son in the morning, and then we're going to rush to play basketball with my daughter in the afternoon, and then play again on Sunday. So that's what I enjoy, running around with the kids, playing sports. All right, Mr. Thompson. All right, Mr. Thompson, you are Jason Wayne Thompson, correct? Mr. Thompson, if you'll raise your right hand, I'm going to place you under oath. Mr. Thompson, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Mr. Thompson, you've appeared on this case previously, and you've waived your right to counsel, stating that you understand that you have the right to have an attorney represent you in this matter, but you have waived that right and chosen to represent yourself. And you've spoken to the state, and you've entered into a plea agreement wherein you're going to be pleading guilty to the Class B misdemeanor offense of possession of marijuana less than 2 ounces in exchange for a recommendation of 3 days confinement as your sentence, excuse me, with credit for time served for 3 days. You would also receive a $1,000 fine, $270 court costs, and a $15 reimbursement fee. Is that the agreement that you've reached with the state? I have to tell you that the range of punishment for a Class B misdemeanor is confinement in the county jail not to exceed 180 days or 6 months, and a fine not to exceed $2,000. And it appears to the court that this plea agreement would be lawful in that it falls within that range of punishment. So I'm going to ask you, Mr. Thompson, how do you plead to the Class B misdemeanor offense of possession of marijuana less than 2 ounces? And are you pleading guilty because you are guilty for no other reason? And has anyone threatened you, forced you, or pressured you to plead guilty? Are you a United States citizen? You read, write, speak English? Have you ever been diagnosed with any type of mental condition? All right, the court's going to accept Mr. Thompson's plea of guilt. Court's going to admit State's Exhibit 1, stipulation of evidence. Court also takes judicial notice of Mr. Thompson's judicial confession. Anything else from the state, Mr. King? Anything from you, Mr. Thompson? Mr. Kane, we may need to audit some of our recent pleas. I've just now noticed that on this plea agreement, it says date of judgment entered was July 8th. So any of these that may have been pre-prepared, we may want to check on those dates because I haven't noticed that before, but we may want to check. Maybe audit the last 5 or 6 and make sure our dates are correct. And Mr. Thompson, your signature appears on several of these documents. Are you telling me that you've read and understand each of the documents that you've signed and that your signature attached is your true and correct signature? All right, Mr. Thompson, based on the evidence before the court finds there is sufficient evidence to convict you of this offense. Court convicts you of the Class B misdemeanor offense of possession of marijuana less than 2 ounces. Court follows the plea agreement in this case, assesses your punishment at 3 days confinement in the Van Zandt County Jail. The court awards you 3 days credit for time already served. Court assesses a $1,000 fine, $270 court cost, $15 reimbursement fee. Are you going to be able to discharge any of your fines and fees today? You are? All right, Mr. Thompson, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. I'm going to have you step to your left here with my bailiff to be fingerprinted. Once you are fingerprinted and you receive a copy of your judgment, I'm going to have you step across the hall and you can start discharging your fines and court costs with the clerks, okay? Just go ahead, step over to your left right there. My bailiff will get that for you. She likes to work and earn money, so. All right, when I call your name, please say present or here, raise your hand so I can acknowledge you for the docket. Trayvon Colton. Thank you, Mr. Colton. Tyreek Joyce. Thank you, Mr. Joyce. Wade Mitchum. Thank you, Mr. Mitchum. Good. Good. Are all of those pleas? I see Trayvon Colton's on arraignment. Is he a plea? Do you know?
We'll have to check on all 3 of those.
Well, the other ones say plea or yeah, they
The
all.
others say plea?
The other 2 say plea. Wade Mitchell and Tyreek Joyce are pleas.
So what was the other one?
The only one I don't see is Trayvon Colton. It says arraignment. Yeah, Trayvon Colton. Ms. Hutcherson. All right, Ms. Hutcherson, raise your right hand. I'm going to place you under oath. Ms. Hutcherson, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you may put your hand down. All right, you are Catherine Marie Hutcherson. Is that correct? And Ms. Hutcherson, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? You have? Bipolar? Okay. Are you currently on medication for bipolar? When was the last time you were on medication for bipolar? Huh? It's been years. Do you feel like the fact that you're not on medication today for your bipolar is in any way affecting you to where you would not understand the proceedings that are being brought against you? So you feel like you have clear mind today and you feel like you understand everything? I know, might be silly questions to you, but they're ones that I have to ask, right? Okay. So you feel like you understand these proceedings and you want to continue to go forward. It's my understanding that you have waived your right to counsel in this case. That tells me that you have been admonished and advised that you have the right to have an attorney represent you. It could be one that you hire, it could be an attorney that's appointed to you if you can't afford one. But you have, in this case, elected to waive that right to counsel and to proceed in representing yourself. And you have negotiated an agreement with the state, and you're asking the court to approve that today. Is that right? And it appears that the agreement you've reached with the state is for your Class B misdemeanor offense of criminal trespass, is that you're going to plead guilty to that offense, and the state's recommending that your punishment be assessed at 4 days confinement in the county jail, with you receiving credit for 4 days time already served. In addition, you would have a $500 fine and court cost of $270 and a reimbursement fee of $15. Is that your understanding of the agreement? All right, Ms. Hutcherson, the range of punishment for a Class B misdemeanor in the state of Texas is confinement in the Van Zandt County Jail for a period not to exceed 6 months or 180 days, and a fine not to exceed $2,000. It appears to the court that your plea agreement with the state would be lawful in that it falls within that range of punishment. So at this time, I'm going to ask you, how do you plead to the Class B misdemeanor offense of criminal trespass? And Ms. Hutcherson, are you pleading guilty because you are guilty of that offense? Okay, no one's threatened you, forced you, or pressured you to plead guilty. All right, court accepts Ms. Hutcherson's plea of guilt. Court admits State's Exhibit 1, the stipulation of evidence in this case. Court also takes judicial notice of Ms. Hutcherson's judicial confession. All right, Ms. Hutcherson, based on the evidence before the court will find that there is sufficient evidence to convict you of the Class B misdemeanor offense of criminal trespass. The court will follow the plea agreement in this case, hereby convicts you of that offense, assesses your punishment at 4 days confinement in the Van Zandt County Jail. Court awards you credit for the 4 days time already served on that sentence. Court assesses a $500 fine, $270 court cost, and a $15 reimbursement fee. Ms. Hutcherson, are you going to be able to discharge any of your fines and court costs today? Okay, so how are you going to take care of that? All right, so I'm going to order you to report to the Van Zandt County compliance officer at the end of the hall on your left. Speak with Ms. Bonnie LaPrade. Your failure to pay your fines and your court costs will result in the court issuing a warrant for your arrest. It's no good for you to be rearrested and put back in jail. It's no better for you than it is for us. You cost us money when you're over there. We'd rather you just get on a payment plan and take care of everything. Well, I can't hear what you're saying. Did you say? It's not better. It's not better. It's not better. But that's possible. If you don't pay it, $500, $270, that may be a lot longer sitting in jail than you want. So, all right, Ms. Hutcherson, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. I'm gonna have you step over to your left to be fingerprinted with a bailiff, get a copy of your judgment, go see my court compliance officer, make a payment plan, and pay it out. Some people just don't learn. Do we find out on Mr. Colton if he's,
Judge, I do believe that is a true range. I don't believe it's-
and we do have, and the other ones are police. Mr. Joyce and Mr. Mitchell are police, so I don't need them up here,
I
right?
do believe so, Judge.
Do I need to call them up and ask them?
If we could just confirm with them that that's still what they want.
Mr. Mitchell and Mr. Joyce, do you already have plea agreements worked out with the state? You do, both of you? Mr. Joyce, you as well? You do? All right, so Mr. Colton? All right, Mr. Colton, you are charged with the state jail felony offense of possession of a controlled substance in penalty group 1, less than 1 gram. Are you going to represent an attorney to, I'm sorry?
I'm representing myself.
You're going to represent yourself? Well, that's only going to be, you're only going to be able to do that if I approve that. Are you a licensed attorney? You understand that this is not a misdemeanor offense. You're facing up to 2 years in prison, day for day sentence. You understand that? You do? Have you ever represented yourself in any of your other cases that are felony degree?
Well, you give me time to get a lawyer and listen to the rules.
Court will, if you're going to hire an attorney, you have the absolute right to have counsel represent you in this matter. And it's always in your best interest to have an attorney represent you, but especially in your case, Mr. Colton, for a state jail felony, it would definitely be in your best interest to have legal counsel. Okay. So what I'm going to do is I'm going to set you for September 30th. And I'm going to set you for 4 p.m. I'm just going to set the same time. And you're to hire an attorney and have that attorney make an appearance in your case on that date. Okay. So I'm going to have the bailiff here fill out a notice of setting for you. I want you to review that and just sign at the bottom. It's going to have that date and that time. We're going to give you a copy and then a copy for your attorney. Okay. And bailiff, before you tear that apart, can I see that real quick? All right, Mr. Colton, there's 2 copies, one for you and one for the attorney, and you're to be back on September 30th at 4 p.m. All right, you're free to go. I like to write the charges on there and what the purpose of the hearing is, so that if he gives it to an attorney, the attorney's going to know what stage we're in and what level it is, because he may not know, he may not remember the defendant. Do you need a break, Tara? Yeah, good. Do it. All right, gentlemen, each one of you has been charged with a Class B misdemeanor offense of possession of marijuana less than 2 ounces. And that carries a range of punishment of confinement in the county jail not to exceed 6 months, 180 days, or a fine not to exceed $2,000. Do each one of you understand that range of punishment? Mr. Joyce, Mr. Mitchell, Mr. Bice?
Yes.
All right, and each one of you gentlemen have also previously appeared in this case and have waived your right to counsel after having been advised that you have the absolute right to have an attorney represent you in this matter, meaning you could hire an attorney, or if you're indigent, an attorney could be appointed to represent you, or you could waive that right to an attorney and seek to represent yourself. And it's my understanding that each one of you gentlemen have waived your right to an attorney and have sought to enter into a plea agreement with the state. Am I correct in that? Mr. Joyce, Mr. Mitchell, Mr. Vice? Okay. Mr. Joyce, well, let me ask each one of you this. I need to know if each one of you are a United States citizen. And I'm just going to point to you. We're going to go in that same order. Mr. Joyce, Mr. Mitchell. And have any of you been diagnosed with any type of mental conditions? Mr. Joyce? Mr. Mitchell? Mr. Bice? No. And do each one of you read, write, and speak English? Okay. And each one of you have reviewed these documents and your signature appears throughout, and you would certify to me that your signature as it appears on these documents is your true and correct signature, and you've only signed these documents after you've read them and you're telling the court that you understand everything that you read and signed. Okay. All right. Mr. Joyce, it appears in your case, the agreement is that you're going to plead guilty to the possession of marijuana Class B misdemeanor. And the plea agreement is 4 days confinement in the Van Zandt County Jail with 4 days credit for time served. Additionally, you're going to have another case, 2020-206, be dismissed under Section 1245 of the Texas Penal Code. You would have a $1,000 fine, $270 court cost, $15 reimbursement fee. Is that your understanding of the plea agreement? And Mr. Mitchell, in your case, the agreement is very similar. 4 days, you're going to plead guilty for 4 days confinement, 4 days credit for time served, a $750 fine, $270 court cost, $15 reimbursement fee. And Mr. Bice, in your case, the agreement is plead guilty to that offense for 3 days confinement in Van Zandt County Jail with credit for 3 days served, a $1,000 fine, $270 court cost, and $15 reimbursement fee. Is that correct? All right. So I'm going to ask each one of you, I'm going to begin with you, Mr. Joyce. Mr. Joyce, to the Class B misdemeanor offense of possession of marijuana, how do you plead? Mr. Mitchum, how do you plead to that same offense? And Mr. Bice, how do you plead to that same offense? All right, the court's going to accept the pleas of each of the defendants respectively, and the court is going to admit, well, let me ask you this. Mr. Joyce, Mr. Mitchell, and Mr. Bice, are all of you gentlemen pleading guilty because in fact you are guilty and for no other reason? Mr. Joyce, Mr. Mitchell, and Mr. Bice?
Yes.
Okay, and you would tell the court that no one has pressured you to plead guilty or do anything against your will. Is that right, Mr. Joyce? Is that correct, Mr. Mitchell and Mr. Bice? All right, the court's going to accept the pleas of each defendant respectively, and the court is going to admit State's Exhibit 1, the stipulation of evidence in each case, and take judicial notice of each of the defendants' judicial confessions. Anything further from the state?
Nothing in each case, Your Honor.
Anything from any of you gentlemen? Anything that you have questions about, you don't understand, or you want to be heard on? Okay, there being none, I'm going to take a moment to review each one of these documents. All right, Mr. Joyce, upon reviewing the evidence, the court's going to find that there is sufficient evidence to convict you of this offense. The court hereby follows the plea agreement in your case, convicts you of that offense, assesses your punishment at 4 days confinement in the Van Zandt County Jail, gives you credit for 4 days served. The court dismisses under section 1245 of the Texas Penal Code, cause number 2020-206. Mr. King, is there a 1245 dismissal? Usually we'll get a 1245 dismissal order with that.
Okay,
Mr. Joyce, and it's cause number 2020-206. I don't know the charge. 2020-206 for Mr. Joyce. Court assesses your fine at $1,000, court costs at $270, and reimbursement fees at $15. Are you going to be able to make any payments towards your fines and fees today? All right. So, Mr. Joyce, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. I'm going to have you step to the left here with my bailiff to be fingerprinted. After fingerprinting, you're going to get a copy of your judgment. And once you get your judgment, you're free to go. And I'm also going to give you a card for the court compliance officer. And you're going to need to give her a call next week. Stay right there. She's going to fingerprint.
Judge, which case has the driving license invalid? We just 12.5%.
Yes, Mr.
We
Joyce.
don't have one, and everyone's trying to figure out. I will present one to Judge Winters or you Monday. So you can get that resolved.
Okay. Do me a favor and let him know that if he doesn't pay, I'm gonna issue a warrant for his arrest. Will you tell him that? I meant to tell him that before he left. I'm gonna tell these gentlemen, but I forgot to tell him. All right, Mr. Mitchell, based on the evidence before the court and your judicial confession, the court is going to follow your plea agreement. The court hereby convicts you of the Class B misdemeanor offense of possession of marijuana less than 2 ounces, assesses your sentence at 4 days confinement in the Van Zandt County Jail, issues you credit for 4 days time served. Court orders you to pay a $750 fine, $270 court cost, and $15 reimbursement fee. You're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. And are you going to be able to make any payments towards your fine today? Today?
Yes, sir.
Very good, very good. All right.
What's the maximum total cost?
It'd be 750 plus 270, so 9, 10, 20, about 1,035. All right. All right, you're hereby remanded to the custody of the sheriff, carry out the terms and conditions of the sentence. I'm gonna have you go with the bailiff here to be fingerprinted. Once you get a copy of that judgment, then step across the hall to the clerk's office and they can assist you. Thank you for taking care of that today. Mr. Bice, I'm gonna need you to sign the stipulation of evidence right here. And I'm also gonna show you what's gonna be attached to that is goes with that, Mr. Bice, is this form right here, which is the, go ahead and show him that. That's the charging information, complaint information. That's what legally brings you to court. So that's what's going to be attached to this document right here, okay? All right, and then Mr. Bice, I'm going to need you to sign here. This is the state's certification of the evidence in your case. That document says that the state has furnished and shown you the evidence they have against you. All right, Mr. Vice, based on the evidence before the court is going to follow the plea agreement in your case as well. Court hereby convicts you of the Class B misdemeanor offense of possession of marijuana less than 2 ounces. Court assesses your punishment at 3 days confinement in the county jail. The court issues you credit for 3 days' time already served on that sentence. Court orders you to pay a $1,000 fine. Court costs in the amount of $270 and reimbursement fees of $15. Will you be able to make any payments on your fines and fees today? Okay, then you're hereby remanded to the custody of the Van Zandt County Sheriff so they can carry out the terms and conditions of your sentence. When you get after you get fingerprinted and you get a copy of your judgment, then just step across the hall to the clerk's office. You got about 10 minutes, then you can make that payment. Afterwards, you'll need to contact Miss Bonnie LaPrade, the court compliance officer, and make arrangements to pay out the rest of it. And as you've heard me say before, your failure to pay the remaining amount of your fines and costs will result in a warrant being issued for your arrest, okay? All right, step over here to be fingerprinted.
Mr. Joyce's, it was the Associated.
Perfect. Oh, and goes with Mr. Bice.
Rachel, you go upstairs. You just give that to them as well. Thank you.
Yes, ma'am.
He's saying he'd like to fight it, and so I shouldn't get it, but you may want to call him up here, you may want to get an attorney.
Okay. Okay, cool. All right, Mr. London. All right, Mr. London, come on up. If you will, sir, raise your right hand. I'm going to place you under oath. Mr. London, do you swear that the testimony you give to the court today in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. All right, you are Shamar Dwayne London, is that correct? And Mr. London, are you a United States citizen? And you do read, write, and speak English? Have you ever been diagnosed with any type of mental condition? Okay. And you've appeared in this case previously and been advised of your right to counsel, is that right? And you've waived that right to counsel and indicated to the court that you wish to proceed by representing yourself. And you understand that you still have the right to an attorney today, but you're asking the court to allow you to proceed with your self-representation, is that right? And it appears that you have reached an agreement with the state of Texas on your possession of marijuana charge less than 2 ounces, a Class B misdemeanor. First, I want to tell you that the range of punishment for a Class B misdemeanor is confinement in the county jail for a period not to exceed 180 days and a fine not to exceed $2,000. Any agreement you have must fit within that range, okay? And I see that your plea agreement is that you're going to plead guilty, and the recommendation is 4 days confinement in the county jail that you received credit for 4 days of time that you've already served on that sentence, a $500 fine, and the state is agreeing to dismiss an unlawful carrying of a weapon that's also been filed, cause number 2020-211, under section 1245, with the agreement that you're going to forfeit the weapon in that cause to the state of Texas. Is that your understanding of the agreement? You know, in addition, you would have court costs of $270 and reimbursement fees of $15. And that's what you want to do. Okay. So let me ask you at this time then, how do you plead to the Class B misdemeanor offense of possession of marijuana less than 2 ounces? And Mr. London, are you pleading guilty because you are guilty of that offense? And no one's threatened you, forced you, or pressured you to plead guilty, is that right? Court will accept Mr. London's plea of guilt. Court admits State's Exhibit 1, the stipulation of evidence, and takes judicial notice of Mr. London's judicial confession. And Mr. London, is it true that you have signed several of these documents here today, and by your signature, I can understand that to mean that you have read everything and that you understand these documents, and that's why you signed. Is that correct? And this is your true and correct signature. Is that correct? All right, Mr. London, based on the evidence before the court's going to find that there is sufficient evidence to convict you of this offense. The court will follow the plea agreement in this case. Court hereby convicts you of the Class B misdemeanor offense of possession of marijuana less than 2 ounces. Court assesses your punishment at 4 days confinement in the county jail. The court will give you credit for 4 days time served. Court assesses a $500 fine. Court dismisses cause number 2020-211, the unlawful carrying of a weapon. Court hereby orders the forfeiture of the weapon from that unlawful carrying of a weapon charge. Court assesses court costs in the amount of $270, reimbursement fees of $15. Mr. London, will you be able to make any payments towards your fees today? Okay. And Mr. London, I'm going to hereby remand you to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence, and have you step to your left to be fingerprinted with the bailiff. After which, I want you to step across the hall and pay on your fines and court costs. If you do not pay them off in full today, then you're going to need to call Ms. LaPrade to make arrangements to discharge the rest. Yes. Thanks, appreciate it. All right, Mr. Pizer. All right, this is cause number 2020-116, State versus Austin Blake Pizer, wherein Mr. Pizer has been charged with assault causes bodily injury, family member. Mr. Pizer, I believe you previously waived your right to counsel to speak with the state. And I believe you indicated earlier that you thought you may have had a plea agreement worked out with the state, but it's been indicated to me that at this time, there's no agreement between you and the state to resolve your case. Is that correct?
As far as I'm concerned.
What does that mean, as far as you know?
As far as I can remember or recollect, I do believe that we had come to a plea of, 12 months probation or something.
Have you spoken with the state today?
Not today. But we spoke earlier. I'm actually trying to fight this due to the fact that this was a competing cause for prior court case.
Okay, well, I don't want you to divulge too many facts about your case because you're not represented at this time. So, Mr. Pizer, are you going to hire an attorney to represent you? Have you previously applied for a court-appointed attorney? Did you apply when you were in jail? All right, Mr. Pizer, this is what we're gonna do. I'm gonna reset you for September 30th. And between now and that time, you're gonna have to come up to the courthouse, 3rd floor, this floor, into the hallway and speak with Miss Patty Taberham. And that's the indigent defense coordinator. You can apply there and she will be able to tell you whether or not you can have a court-appointed attorney. And then when you come back, you're gonna do that well in advance of September 30th. And so if you get an attorney before then, you will know it and you'll tell them about your setting on September 30th. And if you do not apply, if you do not qualify for an attorney, then you'll have to hire one for that day. I'm going to set you not at 4:30. I'm going to set you at 9 a.m. that day. The bailiff has a notice of appearance. She's going to have you sign there at the bottom, indicating that you'll be back on September 30th at 9 a.m. All right, Mr. Pizer, once you have that, you're free to go. We'll see you back on September 30th at 9 a.m. Your name, sir? All right, Mr. Luloff. Okay, so it's gonna be a plea? Okay, that's fine. That's fine. Glad you showed up. I had a note to issue a warrant for your arrest.
Yes, sir. I saw Joshua Winters in June, and I've already talked to him. They told me that everything was good. I just need to set the payment plan. They'll like them call me twice. That's why I was super confused why I had that court today. I'm like, I'm so prepared for it.
Well, you're here now. That's the thing that counts. So.
That definitely was a big issue.
That probably would have caused a little kink in your life.
Yes, sir. I wrote that we're gonna have our baby in 2 months. I just got stitches. And it was last thing I need to worry about.
That's true. That's very true. You got bigger priorities ahead of you.
Sir.
All right, we'll be with you in just a moment.
We call our names today?
Yeah, let's do it. You want to go call them while we're finishing up this last plea?
Sure.
All right, let's take it from the top.
Okay.
Ready? And I'm sorry, it's a long list, but Sean Burleson,
Got him.
Angela Carroll,
Okay.
Amber Crisp,
Yep.
page 4, Jeffrey Cackley, Jeremy Johnson.
I'm sorry.
You want me to slow down?
Page 4,
Page 4.
our pages are different.
Oh, I'm sorry.
Jeremy Cackey.
Yes, I'm sorry. Page.
That's okay. What time frame? I see.
He was at, okay, I'll tell you the time, 9:30.
Got Mr. Cackey.
All right, Jeremy Johnson, 9:30.
Got him.
Alec Carlin at 10 a.m.
Him.
Bria Nichols at 10 a.m.
Got her.
Frankie Rodriguez at 11.
Yes, sir.
Benjamin Rose at 11.
Yes, sir.
Rodolfo Segura Estrada at 11:30.
Yes, sir.
Dikembe Small at 1:30.
Yes, sir.
2 p.m. Angelina Thomas.
Yes, sir.
At 2:30, Amber Valdez.
Yes, sir.
At 2:30, Gerardo Velasquez Hernandez.
Yes, sir.
Just like that. I want you to say it just like that.
I'm on it.
At 3 p.m., James Brian O'Brien. You gotta say it like that as well. I really want to hear you get into it. I will do it again. The real, I want a real thick Irish. I'm sure that's the right way. And that's all that I have. That's all that I show.
Very good. Thank you, Judge.
Did you see anybody that I didn't? There was a release of surety on Jose Gomez that you may have had nice eye by, but there's a release of surety on him, so that'd be duplicative.
I trust your words.
Well, let's not do that. Let's not say that. All right, we ready?
I just want to sneak in before you do that. This was the Tyler Taflock who pled earlier. If you could just sign right here.
Oh, I'm sorry. You handed that to me, and
You did in fact receive it. I'm
I did, in fact.
reporting with my, Code of Criminal Procedure duties on such things. We're almost done. We're almost done.
You're getting comp time. Oh, no, you're not. No, yeah, you're hourly, aren't you? Yeah. You're making big money.
The only one not making comp time is the man sitting behind here.
That's right. All right, Mr. Luloff. Luloff or Loloff?
Lulaw.
Luloff. Come on up, Mr. Luloff. All right, Mr. Luloff. Raise your right hand. I'll place you under oath. Sir, do you swear that the testimony you give to the court today in this matter will be the truth, the whole truth, and nothing but the truth, self you got?
Yes, sir.
All right, you may put your hand down. I like your pants. I guess you came in shorts today, right? Last minute? Hey, you came. That's, like I said, that's the main thing. I'm not going to hold that against you. I'd rather you show up in shorts than not show up at all, you know?
When she told me I was gonna come here, I went to go search for cars, see if I had any, all I had was some long johns.
That's probably a good choice. Thanks for making the right choice. All right, Mr. Luloff. I'm glad you got a good disposition about you. All right, you are Brayton Douglas Luloff, right? And Mr. Luloff, are you a United States citizen? Do you read, write, and speak English? And have you ever been diagnosed with any type of mental condition? And in this case, you are charged with a Class B misdemeanor offense of possession of marijuana less than 2 ounces that carries a range of punishment of confinement in the county jail for a period not to exceed 180 days and a fine not to exceed $2,000. Previously, you've appeared in this case and been informed about your right to counsel, and you have waived your right to counsel and asked the court to allow you to represent yourself. And in doing so, you have met with the state and you have reached an agreement with the state wherein you're going to plead guilty to this offense in exchange for a recommendation of a 4-day sentence with credit for time served for 4 days, a $500 fine, and then court costs of $270 and reimbursement fees of $15. Is that your understanding of the agreement? Okay, very well. All right, and you understand that you still have the right to counsel today, and if you want to stop and get an attorney, you can do so. But you want to proceed representing yourself. All right, Mr. Luloff, then to the Class B misdemeanor offense of possession of marijuana less than 2 ounces. How do you plead? And Mr. Luloff, are you telling me that you're pleading guilty because in fact you are guilty of committing that offense? Has anyone threatened you, forced you, or made you plead guilty to this offense? All right, court accepts Mr. Luloff's plea of guilt. Court also admits State's Exhibit 1, the stipulation of evidence. It takes judicial notice of Mr. Luloff's judicial confession. Anything further from the state?
Nothing this time.
Anything further from the defendant? All right. Give me just a moment to kind of go through these, Mr. Luloff, and then we'll get you out of here. Oh, this said August 21st of 2010. That's back in time. I hope you wouldn't be smoking pot at 11 years old, 10 years old. I'm not surprised. Got to remember what I see and hear up here. All right, Mr. Luloff, based on the evidence before the court and your judicial confession to me, court's going to find that there is sufficient evidence to convict you of this offense. The court follows the plea agreement in your case, convicts you of the Class B misdemeanor offense of possession of marijuana less than 2 ounces. Court assesses your punishment at 4 days confinement in the county jail, issues you credit for 4 days time served, assesses a $500 fine, $270 court cost, $15 reimbursement fee. You gonna be able to make any payment towards your fines today? Okay. I don't know if the clerks are open across the hall, so go across the hall. If they're not open, then you can come back next week, 8 to 5, and you can make a payment. If you cannot discharge all of your fines and fees, then pay what you can, and then you're gonna call the lady on this card, Miss Bonnie LaPrade, and you can speak with her about setting up a payment plan, okay? All right, I'm gonna have you go with the bailiff here to be fingerprinted, and then we'll get you a copy of this judgment, and you'll be free to go, okay? Mm-hmm. Congratulations to you on your baby. Good luck. Quit smoking weed and be a good dad, okay?
I'm gonna try.
No, you're not gonna, well, if you're just gonna try, that's not very good. That's what your kids don't want to hear you say you're gonna try.
My girlfriend thinks I'm doing good. So,
Well,
to me,
we'll do better than good. Do better than good.
yes, sir. Thank you.
You're welcome. Any responses on the nice size? Hang on, you haven't shut down, have you? We gotta do our nice size. Are you afraid of comp time? Oh, goodness. Time and a half, that's, what is it? Oh, cool. That's exciting. Sorry, we'll go quick. Any responses to the names called?
No response, Your Honor.
All right. The court having called the following names. These individuals were not present in the courtroom. Their names were called loudly and distinctly 3 times in the courthouse with no response. The court is going to issue judgment nisi and alias capias and will issue new bail in each case. Sean Wayne Burleson, Angela Carroll, Amber Crisp, Jeffrey Cackley, Jeremy Johnson, Alec Carlin, Bria Nichols, Frankie Rodriguez, Benjamin Rose, Rodolfo Segura Estrada, Dikembe Small, Angelina Thomas, Amber Valdez, Gerardo Velasquez Hernandez, James Bryant O'Brien. Did you type that down correctly when I said it? You did. Did you type it with the Irish accent?
with the roll on the R.
Those individuals' names will receive judgment, not size any of these cases. I believe that's a wrap.
Can you make a copy of your docket?
No.
Please.